This is WPSL Port St. Lucie.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, Treasure Coast. How is everybody on Friday morning? Give me a call and let me know. Give me a call and ask your questions. Maybe we can give you some answers or guide you to where those answers may be found. We have an interesting show today. Some of it is simple, which is good. Some of it gets a little bit complicated. It's landlord tenant law. It's sort of the continuation from 2 weeks ago. We were going to do this part last week, but instead we did a show regarding the retirement of Justice Kennedy and its potential impact on the court for the next generation or two. So today, first of all, I'd like to thank those of you who have been calling my office, which we appreciate. A number of you have called to see if you may have a case. We've had a few of you recently into our office for consultations. A couple of you have become clients, so we appreciate that as well. We had a gentleman in yesterday, and I don't know if he's listening. I'm not going to mention names. I am going to ask my paralegal, who is listening, to give him a call. He came in late in the day, and it was an issue of code enforcement. And the question really came down to whether or not in Port St. Lucie he could be cited for a violation where half the neighbors on his block and on the surrounding blocks have the same violation, and he's the only one being cited. So we took a look at the citations, we dealt with the procedures, and I told him I would do a little bit of research on whether or not code enforcement has the same standard applied to it with regard to selective enforcement. I told him, for example, I know in homeowners associations, they cannot selectively enforce their rules and regulations and their bylaws. They either apply it to everybody or it can't be applied at all. But honestly, I was not sure if that applied under statute to codes.
How do you find out if the other neighbors were cited or not cited? Is there a record of that, or?
Well, you can ask for public records requests.
Okay.
It's one of the things he did do on his own.
Okay.
And
so he does know he's being singled out.
Oh, yes, he does.
Ooh.
And basically, to sort of follow up on that question, what you do if you want to find out what's going on in your neighborhood and you think that maybe you are being singled out, you simply send what's called a public records request. It's a simple letter, it could even be an email, to the city, the public records department. You say, this is a public records request under the Florida Public Records Statute. That way there's no mistaking what you're asking for, because then if they don't give it to you in a timely fashion, theoretically, if you have to sue them, and we did do that once, you get attorney's fees. They got to respond to your public records requests. So what you do is you make a public records request and you ask for all citations that have been issued in the last 6 months or 12 months with regard to a particular issue, in a 5-mile radius of whatever. And you're going to get the documents and you're going to get the information, and you or your attorney are going to be able to make some intelligent decisions at that point. So the information, since it was late in the day yesterday, that I found out this morning when I was doing a little bit of research on selective enforcement and codes that cities and towns have throughout Florida, is this. According to the 11th Circuit Court of Appeals, which is our Court of Appeals, the 11th Circuit has recognized that plaintiffs may bring an equal protection claim for the unequal administration of a facially neutral statute so long as intentional or purposeful discrimination is shown on the part of the state. In this case, it would be the city. It went on to say, to prevail on this selective enforcement claim, a traditional type of equal protection claim, the plaintiff must show, 1, that it was treated differently from other similarly situated people, and 2, that the defendant unequally applied a facially neutral ordinance for the purpose of discriminating against the plaintiff. So that's, when lawyers do this, that's like my thumbnail research that I found relatively quickly. And now, if I had to actually pursue the issue, the next step is for me to go on, there are about 3 of them or 4 of them, but 2 primary lawyers, computerized research tools. I happen to use Lexis. For many years, I used Westlaw. And now I'm going to start plugging in these search parameters. I'm going to limit it to the 11th Circuit in Florida. Mm-hmm. And I'm going to find out as much as I can with these buzzwords, selective enforcement, code, ordinance. And I'm going to now get more information than I just got with a thumbnail that is going to tell me the circumstances under which selective enforcement really is not permitted and where there's wiggle room, which better enables me to advise a client. So, Cheryl, give the gentleman a call. Let him know that selective enforcement is not permitted. And if he needs to at a future date, because I know what he's planning on doing right now, let him know to give us a call and we may be able to assist him. So that's sort of what happens. Attorneys don't always have the answers.
But you guys know how to find those answers.
And that's the interesting thing. In law school, it's hard when you're there 33 years ago. In law school, they used to tell you your first year of law school, you're going to learn lots of law. And by the time you're out of school, half of it will have changed.
Okay.
And 20 years from now, 80% of it may have changed.
Sure.
And a few years, Roe versus Wade may have changed. But we're not here to teach you the law. You're learning lots of law, but we're not here to teach you the law. It's not the purpose of law school. Mm-hmm. The purpose of law school is to train you to think like a lawyer and to learn how to find the answers. And so you may, as an attorney, over time, become a specialist in an area, and your wealth of knowledge that is sitting within your brain may be a lot more extensive on an area than somebody else, and if so, that's a good person to go to for a client because you're not reinventing the wheel. On the other hand, there are a lot of general areas, and there are lots of general civil litigators. And what we're trained to do is we know various areas of law that we practice more often. Mine happen to be employment and discrimination and civil rights. But lots of other things come in the door, and I handle lots of other things. And in those situations, my training, first of all, should give me some ideas as to what I can preliminarily advise the client. And then the follow-up is research, which often I will try to do before somebody comes into the office when I know what their issue is, just so that I know what statute applies, what the general law is, and we can try to give them some advice and see whether or not we're going to go to the next step. But that's it for selective enforcement. That's code. It's not landlord tenant. So
that's still very interesting, though, because and you wonder, okay, the code enforcement person drove down that block and picked out that situation to write the ticket. This resident sees it at other locations. Why not everybody get a ticket?
Well, I'll tell you an interesting little story that applied to me, and I told the gentleman this yesterday in the office. I moved into a new home 2 years ago, and at the front of the property near the road are 2 beautiful palm trees. And one day I get a violation notice on my door. I've been there a couple months. The palm trees are on the right-of-way of the city, and they must be removed.
Okay, but they were there when you got the house, right?
Right, but they don't care about that.
Okay.
Okay? But I'm looking, okay, I investigate it. Yep, they're on the right-of-way. Okay, it's a violation of the code. What harm is it doing? So I try to make my argument.
I mean, they're trees. They've been there a while.
And they're pretty.
Yeah, okay.
And so then they come out again, and they look at it, and they say, well, you have an exception for the tree on the right side of your driveway because it's within 6 feet of the mailbox, and the statute has an exception to things within 6 feet of a mailbox. So you can keep the tree on the right side, but you got to remove the tree on the left side. So now it's going to be unequal.
Uh-huh.
Okay? And if you're obsessive compulsive, you don't want that either.
Yeah.
Okay? Or neurotic.
And back to the point, they were pretty.
They were pretty,
Yeah.
right, And I said to him, well, I've been here a couple months. Where is this coming from? And it was a very nice code enforcement officer, really was. And he says to me, I can't tell you who, but somebody complained. I said, well, why would we're on this little...
they don't even know you yet.
We're on this little court, like of 6 homes, and I know nobody there complained. So it has to be somebody, not even on our block.
So somebody decided to pick on the new guy.
Well, actually what it turned out to be is, and he said this happens a lot, somebody gets cited for something, and they start complaining that nobody else is being cited for the same thing.
Okay.
So then the code enforcement officer drives around the neighborhood and starts citing everybody with that problem. And you get caught in the net. And really that's what happened here. I got caught in a net. Now, the average person might have either removed the trees or at least asked for a hearing. I did my own little legal thing. And at the end, I was told the case has been closed.
Okay. Did the trees get to stay?
Oh, they stayed.
Awesome.
So, yeah, sometimes little tricks of the trade. And when the client comes in, that's part of my job. And, if I've gone through it personally, lawyers go through lots of things just like anybody else. Sometimes if you've gone through it, you have a few little other tidbits of knowledge to impart that are practical as opposed to just what's in the law books. All right. Before we go back into hardcore landlord-tenant law for you landlords or tenants out there, let's talk about stupidity.
Do you have enough time in the show?
I only picked out a few. Some of them are from good old America, and since it was just July 4th, some are from good old England. These are some rules and regulations that landlords have or have had for their tenants. See if any of them apply to you folks. If you like graffiti, don't do it. Pull down your pants and graffiti your buttocks. I put in the polite word there. That's a rule.
Okay.
Showers
in America or England?
Well, that one I'm not sure. A couple of them are obvious.
All right.
Showers can last no longer than 15 minutes. I'd like to know how they're going to enforce that.
Yeah. Well, the landlord lives downstairs. He can hear the water running.
That's partially true, yeah. There is no living room included, only bedroom. So if you sit in kitchen area, which is my personal living space, you must eat, then wash up, and go back to your room. I don't think I'd want to move in there.
Oh. And was that in the lease?
It's in the lease. It's a rule and regulation in the lease. Don't leave dishes in sink or a charge of £15 will be added to rent. Obviously, British.
Sure.
No speaking loudly. Anyone found to be above the recommended decibel level will be asked to stop speaking altogether.
I'd have a problem because I'm pretty loud.
But stop speaking altogether?
Altogether.
Oh, my goodness. And for how long?
Forever, because
that's a very vague regulation. And what's the decibel level? See, as an attorney now, I'd be looking at all these things.
What's the acceptable decibel level?
Well, that's up to the landlord. But he didn't specify.
Yes.
Is it freight train level? Or is it...
very quiet.
Right. Any milk theft will result in the police being called.
You know it.
Now, folks, you're not going to believe this one. I swear it is true. This came out of, I'm sure it was England, because obviously we have the pounds issue in here again. No over breathing. Anyone exceeding the oxygen allowance will be forced to pay £15. I don't know why. I don't know where.
How do you measure that?
I don't know. But, it's there. Only red M&Ms allowed.
Oh, I like that one.
Okay. Now, I know that some
some
entertainment people have, things like that in their contracts, for their dressing areas.
The green
but
room,
in a lease?
Yeah.
Last one. This would be a problem for some people. especially as you get older. No excessive use of toilet. Any use of toilet which exceeds the maximum odor level will be asked to vacate the premises following a 2-hour cleaning by a cleaner which you must pay for. So, other than a little bit of levity, which I hope I've injected.
Makes home ownership sound so much better,
doesn't it? And not in an HOA community.
Yeah, they have to be careful there.
You know, when I was recently looking and found my home 2 years ago, I looked at a lot of homes and a lot of them were in HOAs, and we almost bought one in an HOA because it was on the lake and I fell in love. But the taxes were pretty high because it was on the lake. And the owner and I couldn't quite come to agreement as to price. But I was ready to take my chance in being in an HOA. It was a small community, so I was hoping it wouldn't be a big deal. And it was a beautiful place. It looked like everybody kept up their property.
I think the smaller the place, the bigger the deal.
Maybe. But I ended up getting a normal place, that's no HOA, and still code enforcement showed up on my door within 2 months. So I don't know. No, you can't make the right decision no matter what you do. I guess that's the life story. All right. We talked a couple weeks ago about landlord-tenant law in terms of the basics, in terms of what is a landlord required to provide, what does a tenant have to provide, what does a tenant have to make sure they don't damage, things like that. So let's turn instead now to the tenant's right to terminate a lease. I do get a good number of calls over the years about my landlord this, my landlord that. I don't want to pay rent, or I'm withholding rent already. I want out. Can I get out? That is not an easy question to answer. It requires knowledge of all the facts that have been going on, and then I have to look at really how well has it been documented so that you don't have a he said, she said, in landlord-tenant court. But what is the basic rule? If the landlord materially fails to comply with a provision in the lease, something that he is required to maintain, or something in the statute, which is the landlord's responsibility, you as the tenant, I mentioned this 2 weeks ago, you have to provide a 7-day notice. Now, if the landlord still can't fix it within the 7 days, then what we have to look at is, was the landlord unable to fix it because of conditions beyond his control, like a hurricane hit? Was the landlord unable to fix it because it was a big job and he's in the process of working on it?
Okay, he's working on it. All right.
Or has the landlord not even come and checked on it yet? The first two, you're going to have to give the landlord more time. The last one, time's up. Okay? So if time is up, you are able to terminate the agreement. You're able to vacate and legally not be responsible for any rent for the remainder of your rent term. Now, practically, would I advise any tenant to simply leave? No. When I talk about they teach you to think like a lawyer, and as liberal as I am, they teach you to be conservative. So my legal advice is always very conservative. And I would never suggest to a tenant that you just walk out. Instead, whether you're using a lawyer or you're doing it on your own, and sometimes I have a consultation, I just guide people on what to do, I would say, here, we gave you this notice. You have failed to comply. Therefore, we're out of here. Now, that at least puts it in writing. Even better, I think I've done this 3 times within the last year. Negotiate a termination of the lease. All right. The landlord will want something. You're going to have to give something up. Maybe it's part of your security deposit. Maybe it's an extra month's rent. And then what you have to decide is, it's like any settlement. All right, I have the right to just walk out. That's what the law says. If I do that, landlord may sue me, and I may win probably in court, but after maybe paying a lawyer $10,000. So would I rather do what is my legal right, but practically may cost me money, or would I rather negotiate an early termination agreement where maybe I give up a month's rent or half my security deposit, much less than I'm going to have to pay if the landlord decides to sue me? Frankly, I believe that's a better idea. If it's reasonable, if you're trying to get taken advantage of, okay, then just leave and let's see what happens. And so I've negotiated early termination agreements, and the one thing it really gives the tenant who's left is peace of mind. They're not looking over their shoulder as to, am I going to be sued? And if there's 10 months left on the lease, am I going to owe $12,560?
Sure, and then that also goes into your credit report and try to get another place to rent.
That's very true. Okay, so even though you have the right.
Do you want to break for the news in 2 minutes?
Now let's move on, because I think we have some stuff, and then I have a little thing at the end.
Oh, right.
So you have the right then, if the landlord doesn't do it in 7 days, to terminate the lease if you want. Now, what if you don't want to terminate the lease? Then the question becomes, was the problem one that makes the property uninhabitable? If it is, you're allowed to leave for the period of time it takes the landlord to remedy the problem and not pay rent for that period. Again, do you just stop paying the rent? That's dangerous.
But that landlord's not jumping to it and getting it taken care of, so you may be out for a while.
Well, maybe, but just stopping paying rent is dangerous.
Okay.
Now, the alternative is for you as the tenant to file a suit in Landlord Tenant Court so that you can deposit the rent into the registry of the court. Who wants to do that, really? So in those cases, what I recommend to a client, to a tenant, is you write another letter. You explain that this is my legal right. I am withholding rent. I am putting the rent money in a separate bank account so that I can ultimately prove that I did not pay rent because I didn't have the rent money. I didn't pay rent, and I've separated it. So, landlord, if you want to sue me, go ahead. As soon as you do it, I'll put the rent money in the registry of the court, which is what the rules require. So at least if we're going to have a fight, I'm advising the tenant, let's do some things that show that you're wearing the white hat. Law may not require it, but Stuart Address does. Okay, it puts you in the best position to avoid all sorts of claims that you weren't paying the rent and late charges and all that kind of stuff. All right. What if the problem doesn't make the property uninhabitable, but instead it diminishes your ability to utilize all of the property effectively? There's a flooding, the oven stops working, the refrigerator stops working, dishwasher stops working. I guess you can wash dishes by hand, but Then you are, again, if you've given that notice and it hasn't been remedied, you are entitled to withhold rent, but not all of it. You're entitled to withhold the portion of rent that is fair to the diminished use that you have for the property for the period of time you have it. So again, potential client calls me and tells me they're going to do this. And I say, stop, wait, don't just do it. If you're going to do it, at least try to protect yourself. Make it really clear in writing that this is what you're doing. I'm following statute XXX subparagraph, blah, blah, blah. And then, folks, in the law, there's usually subparagraphs. And at least put it on record so if there's ever a battle in Landlord Tenant Court, it is clear what you did and why you did it and what your intent was. And again, segregate the money that you're not paying. The other alternative, again, which, who as a tenant who wants to file the lawsuit, but you can file a lawsuit to have the court determine what percentage of rent you should withhold. And then that goes into the registry of the court, and then you continue to pay the landlord the rest of the rent. So it can get complicated. The law is very simple, fairly simple in that regard, but then implementing it can get complicated because you as a tenant don't want to be on the receiving end of an eviction action because then you're going to have to defend against it. So you want to try to do everything you can to avoid it. Now, what about the landlord's right to terminate? It's a two-way street. The landlord has the right to terminate, and the statute separates the reasons. One is for reasons other than non-payment of rent, and then the other is non-payment of rent. So when a landlord wants to terminate for reasons other than non-payment of rent, let's say you have failed to comply with provisions in the lease. Let's say the lease allows you a 20-pound dog. You have a 125-pound dog. The landlord tells you, get rid of that dog. You don't want to get rid of your dog.
No.
The landlord puts that 7-day notice. You don't get rid of that dog. The landlord can sue you for eviction.
Mm-hmm.
That is a reason other than non-payment of rent. But the landlord has to give you the opportunity to cure, essentially, get rid of the dog.
Mm-hmm.
Yeah.
And then you hide it for a while, the best you can.
I don't hear that. I don't hear that. Hey, fingers in my ears. I don't hear that.
No, I know that's what happens.
If y'all, any of you remember Hogan's Heroes, Sergeant Schultz, I know nothing. I see nothing. Like monkey, whatever. No hear, no see, no whatever.
Mm-hmm.
But really, if that's the situation, you have something you can't correct or won't correct, and it is a violation of the lease. Best thing to do, negotiate an early termination of the lease. Okay, if you're not going to get rid of your dog, and I'm just using that as an example, don't just keep it, because you're going to get thrown out.
Mm-hmm.
And you're going to be on the hook for the rest of the lease. Now, the landlord has an obligation under the law to do what's called mitigate damages. He can't just leave that unit, house or condo, whatever it is, vacant for the rest of your lease term. But if the landlord uses reasonable efforts to find another tenant and doesn't, depending upon the situation, the economy, and whatever, we've had those situations. Can't find another tenant. If you didn't do it the right way, you're responsible for the rest of the money on that lease, and that may end up meaning in a lot of cases you go bankrupt. If we're in a situation right now where there is not a sufficient supply of units in Port St. Lucie especially for demand, then it is highly unlikely that the landlord using diligent efforts will not quickly find another tenant. If the landlord finds another tenant, and that tenant, without it being a game, but that tenant is paying $100 less a month, that's all the landlord could get, you're on the hook for that difference unless you've negotiated an early termination. If the landlord gets a new tenant and he is lucky because of the supply and demand, and he's getting $300 more a month, well, he's not going to be able to sue you for rent. I mean, that's just the facts. So, to protect yourself from what if, what might happen, when is it going to happen, either on your own if you feel comfortable, or with an attorney, try to negotiate a written document, an early termination. I will be out by X. My rent obligation will be until Y. You agree that I'm not responsible for anything else after that in exchange. And here is what's called legally the consideration. In exchange, I give you. It could be a puppy from the litter. It could be $1.
Or your whole security deposit.
It could be your whole security deposit. But that's the reality. You negotiate a document, and for all contracts, there has to be consideration.
Mm-hmm.
So, if your consideration, if you're going to have a litter of puppies, and your consideration is I'm going to give them one puppy, that's okay, folks, but make it in the contract.
Mm-hmm.
All right, so what if your noncompliance has to do with non-payment of rent? Well, that's a tough one because it's fairly black and white. You've either paid the rent on time or you haven't paid the rent on time. If you haven't paid the rent, you're going to get a shorter notice, not a 7-day notice. You're going to get a 3-day notice. And if you have not cured within those 3 days, the landlord at any point after those 3 days can file an action for eviction. Now, this is a good opportunity to go, what does that really mean? So here is how landlord-tenant eviction actions work. Here are the nuts and the bolts. Landlord files a complaint just like in any other case, gets a summons from the clerk that has to be served upon you. It's served upon you in one of the numerous ways permitted under the Florida Rules of Civil Procedure. It can be hand-delivered to you. The sheriff can give it to you. In certain circumstances in landlord-tenant court, there might be certified mail permitted. But you're served. Now, in a normal case, you have 20 days to respond, not in landlord-tenant. You have, I think it's 5, it might be 7, but I think it's 5. Why? Why so little time?
Because you didn't pay the rent.
No.
Oh, okay.
Because the Landlord-Tenant Act is designed on purpose to be a summary procedure statute, to expedite the ability to come to a final resolution quickly. The average civil case in circuit court takes 18 months to 2.5 years, maybe longer, to get to a result if you're going to have a trial.
Mm-hmm.
The average landlord-tenant case, if you're going to fight and have a trial, is over in 4 to 6 weeks. Wow.
Mm-hmm.
It's designed, and rightfully so, that if a tenant justifiably has cause to evict you, that landlord should not be made to have to suffer with you for a longer period than necessary, because that landlord is losing money. And while I generally represent the tenant, and you can probably tell that from the focus of what I'm telling you folks, I've represented a number of landlords as well. You know, it depends on who walks in the door. It's a general civil litigator.
But if the courts get it done in about 30 days, you usually have security deposit kind of covers 30 days.
No, my good
Isn't
friend.
it first, last, and a month security?
You cannot use security for your last month's rent. That's another reason to come after you. No.
But what I'm saying is your landlord is holding that money.
Yes.
And if it takes the system that long, you're really, and if you win as the landlord, you haven't lost anything because you've got the security deposit.
All right, I see what you're saying. That if the tenant hasn't paid the month's rent and it takes about a month to get them out, at the very least, the landlord will take the security deposit. That's fine. What if there are damages to the property? Now the landlord
what do you mean, what if?
Now the landlord either has to make a choice. I'm just going to forget about it, or I'm going to keep this lawsuit going. I got the eviction, but I'm going to keep it going for money damages. That part will take the normal period of time. 18 months, 24 months.
Okay.
That is not part of the summary procedure.
Right.
The only part that is a summary procedure is the eviction issue. So, going back to nuts and bolts. You've been served now, whether it's for non-payment of rent or for something else.
Now, how long do you have now once you've been served to be out?
Well, that depends upon how quickly the court acts. You have 5 days to respond.
Okay.
If you don't respond, there's going to be a default entered against you. That default will then be converted very quickly into a default judgment. And once that judgment is entered, the landlord will be able to get a writ of eviction. That writ of eviction will go to the sheriff. And the sheriff, without any further notice to you, will one day show up on your doorstep and remove all your personal property onto the front lawn. And you're out. That's it. Not the way you really want to leave.
No.
Okay? So let's say you do respond. If it's a non-payment issue, you respond, he's wrong, I paid, I have the receipts. Okay, there's your answer. There's your defense. Okay? What they say, issue has now been joined. Okay? Or you want to answer and you say, well, I've paid on time for 5 years and I was late this one. You're going to lose. Okay? Compassion is not part of the statute. Judge can't even consider it. Let's say it's a eviction action that's not based upon rent. Let's say it's based upon your 125-pound dog.
Okay.
And let's say your defense, let's be creative here, is that that's not what the lease was supposed to say. It wasn't a 25-pound dog. It was a 125-pound dog because we knew I had a 125-pound dog when I moved in. We talked about the 125-pound dog, and I don't know why the one isn't there, but it's supposed to be a 125-pound dog.
Okay.
It's not a bad defense if it's true. It happens. So, again, issue is now joined. So whether it's a non-payment of rent issue or something other than non-payment of rent, now you've responded to the court. An issue is joined. What happens next? In a normal lawsuit, a lot of nothing, or you start depositions, interrogatories, requests for production, requests for admissions. That's not the way it works in landlord-tenant court. Once you have filed that answer, very quickly, probably in a few days, you're going to get an order from the court, again delivered in an appropriate manner, that says here's the date of trial. And that date of trial is going to be anywhere from 2 weeks, 4 weeks, maybe 6 weeks out if they're really busy. And with that, we'll take a break, and we're going to take Bulldog on line 1. Hello, Bulldog.
Hey, Stuart, how are you?
I'm doing good. How are you this Friday?
I'm doing all right. I have a question about you. Now, you're talking about leasing apartments and things like that.
That's right.
I leased a house.
Yes.
And it was a spec house. And he seemed to think that he had the right to parade people through my house because his basic intent was to sell it.
To
now,
flip it, okay.
Is that legal?
Well, did he become
I think
a tenant?
That's invasion of privacy somehow, right?
Well, okay. Did you lease it to him and he now became a tenant?
Oh, no. He leased it to me.
Oh, he leased it to you.
Yeah.
And then
so
brought-
I'm
Oh,
living in the
no,
house.
no.
And then
no,
brought
no,
other
no.
people
Yes,
around
no.
to see it?
No, he can't do that. Within, again, and this one I don't have the precise dates, but within a certain period of time prior to the expiration of your lease, the landlord will have the right to show the property on reasonable hours and reasonable notice. But the landlord does not have that right to enter the premises.
No, and I changed all the locks on it first thing when I moved in. But, of course, I do that. But the thing about it is that he was also complaining he couldn't show all of the property because I had a couple of Malamutes running around.
Well, he had no right to show the property. He leased it to you for, whatever the period was. I guess
it was a
year.
6 month
6
period.
months. Okay.
So,
Then again, I don't know the exact number, but let's say a month before the expiration of the lease, he would probably have the right on reasonable notice and reasonable times. Not 11 p.m. To let you know.
But wouldn't that not coincide with him having to give us, the 30 days notice? Do you want to re-up the lease, buy the house, or move out?
Well, unless it's in the lease, there's no requirement that a landlord give notice. Now, if it's in the lease that you have to give 30 days notice if you want to renew, or he has to give 30 days notice if he wants to terminate. Otherwise, the lease rolls over on a month-to-month basis. That may be in the lease. But if it's not in the lease, then there's no notice required. The lease just ends. If you don't leave, you become what's called a holdover tenant, and it converts to a month-to-month tenancy, which requires less notice to get you out than if you're on that 6-month lease.
And usually
And also
it
gives him
rent
the
goes up.
opportunity to show the house anytime he wants.
Well, if you're a month-to-month tenant, probably on reasonable time, reasonable notice, yeah, I would say that likely he'd be able to show the property.
Right, and that's why I was asking, because as soon as I moved in, he started trying to show that.
Yeah, and I don't think he has that right at all. One of the most basic rights of property rights of tenants is the right to quiet enjoyment. And that means a lot of things, but it also means the landlord has no right to enter the property. It is your property now, and the landlord has no right to enter except for good cause. And that goes all the way back to good old England and the common law. It started out differently, actually. I was reading something because it was just July 4th, it started out, England landlord tenant law started out not leasing property to live in. It was leasing property to farm and live in. And so you paid royalties, you paid your rent, and you paid royalties to the lord of the manor, the landlord.
Mm-hmm.
Okay? But you had rights too, and one of the most basic rights you had was to be free from the landlord's intrusion while you had the temporary property rights to that space. And so that has carried forward all the way to the 21st century here. The landlord does not have that right, and that right is evident in our laws in a lot more ways than just landlord-tenant law. It's the doctrine, king of the castle. It's why warrants are needed to enter your house unless the police believe there's a felony in progress or, it's a matter of life and death. But generally, a warrant is needed because you are the king of your castle. You have the right otherwise to say no.
Thank you so much, sir.
You're welcome, Bulldog. Take care.
Have a good day.
You too.
So remember, when they ask you, "Can I come in?" that you don't have to let them in.
No, you don't. And we've talked about that in the last 20 weeks or 22 weeks. I've represented two people where that's happened, and search warrants, and I don't have the warrant, and it was the wrong place to begin twice. No, you unless there is a warrant there,
Mm-hmm.
and if you ask to see the warrant, and they show you the warrant, they don't have the right to cross the threshold. Now, the mistake that is often made is, well, can I come in to talk to you for a minute? Once you allow them into the threshold, they're in. Now, what they can do while they're in is not unfettered, but you've lost a lot of your protections from search and seizure. So better to keep them outside. And if they won't
talk on the porch.
And if they won't stay, then there's an issue. I mean, you can assert your rights. You'll probably get arrested. I mean, that's what I had one client that was concerned about that. But you do have the right, and the question is whether you give up that right. You also have the right to give it up. I mean, that's the benefit of having rights. You assert it, or you give it up, depending upon what you think is best at that time. So, with the little time we do have left, it's amazing how little you get through on notes on an outline.
It's a quick hour.
Yeah, it does. It does go quick because it's also one of the reasons why when I have a consult in the office, it usually takes longer than I've anticipated because you try to talk and get into details and give analogies and try to give the person the value for, if it's a paid consult, especially what they're buying. We have Gina on line 2. How are you, Gina?
I'm pretty good. And yourself?
I'm all right. How can I help you?
I was wondering, if you have a rental, what's the best way to protect it? Is it put it into an LLC or?
I'm sorry, if you have a what?
If you have a rental.
Okay.
Or what would be the best way to protect it?
What are you trying to protect? That's the first question.
Potential lawsuits, I guess.
Okay. So you don't want the lawsuits to potentially go against you and your assets.
Correct.
All right. Yes. Then the best thing to do would be to put it in some type of a corporate entity. I'm not a corporate lawyer, but corporate lawyers will tell you you can do it in a corporation. You can do it in an LLC. You can create a partnership. Partnerships are not the preferred course because partners can be held liable beyond the partnership. But there are a lot of entities that you can choose from, and each entity has tax consequences and advantages. So that's where a lawyer who really understands that kind of stuff could say, okay, this is what your goal is, this is what your concern is, utilize this vehicle, and here are the tax benefits to you as opposed to if you did that. So I'll give you an example. My law firm is a sub-S corporation. It was explained to me that I would be better off with that than a C corporation. I don't even remember, it's 12 years ago, the differences and all, but I do remember being given the advice. And so I became a sub-S corporation. So yes, if you want to protect that that property so that, oh, God forbid, somebody dies there. And let's say, there was a hole in the front yard, and you knew about it for a long time, and you did nothing to fix it. It's probably better if the property is in a entity format so that if the entity ends up bankrupting, it's not you.
Okay.
Hopefully that answers your question.
Yep.
All right.
Thank you.
You're very welcome. So, in our little time left, instead of going back into the outline, let's just talk about, in general, the reason why these things do take time. And while this is a great format, and I enjoy doing it, there are limitations to this format. And the limitations are, I can give a quick answer based upon general principles if I'm familiar with them, but I can't know for sure based upon all the facts, even facts that you might not realize are relevant, but if I was consulting with you, I would be digging, sometimes performing dental surgery, to get the information I need to try to make sure that the advice I'm giving is the correct advice. Mm-hmm. And when somebody comes into the office for a consult, what we have them do, depending upon the situation, let's say it's a landlord-tenant. Bring the lease, bring any emails, any text messages. If you have photos or whatever the issues are, bring photos. Bring it all. And we'll figure out at the consult what I really need to look at for this initial period and what maybe I don't. And then, during that hour or hour and a half, I'm going to let you tell me your story, whether it's landlord-tenant or employment or discrimination, civil rights, whatever it is. I'm going to let you tell me your story. I mean, I already know a part of it because you've called in and because you've spoken to Cheryl, mm-hmm. and Cheryl's taken notes and talked to me about it. And I finally said, okay, tell them, come on in. So I have some basic information. I may have done some preliminary research before you came in. But I still want you to tell the story as opposed to what I've got from Cheryl, as good as it is. And usually a client, they want the opportunity to tell their story. Mm-hmm. They feel frustrated if, well, I already know because of this, and so let's go right into, no. They want to be able to say what's on their mind, and it's their right. Not legally a right, but practically, reality.
It works out better that way.
If they're going to like me, it's their right, because otherwise they're going to walk away unhappy. And then my job is to interject at appropriate times and ask questions and probe and say, okay, you just mentioned that email. Do you have that email with you? And try to get a much fuller picture of what is going on. What did the landlord do? What did the police do? What happened with the sale of this real estate that is a problem? And once you have that bigger picture, you're much better able, and this is the job of an initial consultation, you're much better able at the end of that consultation to say to a client, all right, these are what I think your options are. These are the pros and the cons of each option. This option I think you can do without me. If it doesn't work, give me a call. But, why do you want to spend all this money on me right now if you can do this yourself? Mm-hmm. Very often that's what happens. Or here's an option, I can do this for you. This is what it's going to cost. Or here are a couple other alternatives. And now you have the ability, with guidance of mine, let's say it's the pros, cons, risks, rewards, to decide how do you want to proceed. Because no two people are identical and are going to make the same decision. Mm-hmm. And it's your matter. You have the right to decide. And so that's really, the way I look at a consultation. It's to get, that type of detail so that the client walks out either thinking about it, knowing what they want to do, or actually having hired me, which is wonderful. And we sort of have a beginning plan and I've told you, well, what else I want you to get for me before I do whatever it is I'm going to do.
Mm-hmm.
So before we run out of time, let me tell you folks something really interesting. Today starts a new show on WPSL. Following my show, Ask a Lawyer, we're going to have Ask a Rabbi. And no, it's not the same person. I am not a rabbi, and I do not play one on radio. But we are going to have Rabbi Shafir Loeb of Congregation Eitz Chaim in Port St. Lucie, which is right opposite the Mets Stadium. So sometimes we sit out there and we watch the fireworks. And the rabbi is, over the course of however long, however many weeks, is going to discuss various aspects of Judaism and interfaith and things of interest. Now, let me sort of give her a little bit of an introduction before she comes in. She is I think she said, I'm going to get it right, she'll correct me. I think either 27th or 37th generation rabbi in her family. It's a lot of rabbis.
Wow.
And she is the chairperson of the Treasure Coast Interfaith Clergy Alliance. Congregation Eitz Chaim, we do spend a lot of focus on interfaith cooperation and understanding. She has a couple PhDs and is in work on another one. She's a teacher of English as a second language to students in China by computer. She's an instructor of world religions at IRSC. When she was in Tucson, she was the chief rabbi of all the congregations in Tucson one of the years she resided there. She's been a chaplain in the armed forces. She's had her own radio show and TV show in Tucson. She's been a pilot, a flight instructor, an engineer at Goodyear, a lot of other careers, gives her well-rounded, a former purebred dog show participant and trainer. And let me tell you something else, my favorite. She is the best challah baker on the North American continent. And let me tell you folks something. Why? You have all plain challahs or raisin challahs, I guarantee you. She makes chocolate chip, M&M, salted caramel, peanut butter, jelly beans, orange creamsicles, s'mores, and more. You got to come to one of our services if you want her challahs, because they are the best in this continent. And anyway, that's all for Ask a Lawyer. Hope to see you next week. My office is 781-8003, and have a great weekend.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.